Assimakis Komninos, very well, welcome to Digital Markets Research Hub. I hope we will have an opportunity today to discuss the latest development in European competition law. So much is going on in different areas of EU competition law. And I also hope we will have this wrapping up of a year as a tradition, which it's already the second iteration. We have it last year and for 2024 as well. I hope it will continue. Thank you very much again for the opportunity to ask you a couple of questions. So probably the best format would be to start with addressing the key cases and your reflections upon them. And maybe we can start with Intel 2.
Well, Intel 2 definitely, first of all, thanks for this opportunity. It's indeed a tradition which I cherish, I have to say. Intel 2 for me is a very important judgment, clearly. Why? Because for the first time, or less, we have a clarification of the clarification. As you may remember, Intel 1, in reality, we had the reversal of the previous case law. They called it a clarification. That's the famous paragraph 138. And we were always a bit, what does it mean? I mean, some people had started talking about a presumption or something like that. So that's clearly not what the court said here. And I think more importantly, the court clarified what it meant. And what it meant is this. Contrary to existing case law, which suggests that a dominant company, an investigated party, can raise for the first time arguments on appeal, and that's the Knauf case law, Galp Energie, etc. Contrary to that, when it comes to these type of practices, when it comes to Article 102, the dominant company has the duty to put all its economic arguments forward during the administrative procedure. That's all. No presumption, nothing at all. In fact, the court uses the word presumption only twice when it refers to the arguments of the Commission and of Germany. And then immediately afterwards, you read the text, nothing about presumption, nothing about presumed, presume, nothing at all. And although the General Court, in my view, wrongly had mentioned that there may be a presumption here, that, for example, if you have certain types of conduct like exclusivity rebates, exclusive dealing, etc., maybe there's a presumption of anti-competitive effects, and then the dominant company can come forward, etc. In reality, no, this is just a procedural rule, the court says. That's, if I remember well, paragraphs 204, 205. It's just a procedural rule that the dominant company cannot stay silent and say, see you in court. No, that has to happen during the administrative procedure. But once the dominant company does that and produces this kind of evidence, then immediately the Commission will have to run a full-fledged effect-based analysis. That's what it is in reality. So that's very important. This clarification of Intel 2 is very important. Of course, there are no presumptions. That's clear. The court also sees exclusivity rebates in the same way like all other conditional rebates. There's no distinction. Like, for example, we will go later to the draft guidelines of the Commission where they make a distinction, but that distinction clearly is not based on the current case law. So that's why I think Intel 2 is extremely important. And of course, there are lots of other interesting stuff there, like, for example, on the importance of coverage, the market, the percentage of the market that is covered by the particular practices, and so on. And then you see also how the court dealt with the general court's analysis of the AC test. I think it's pretty telling, how the court stayed with that and spent so much time and space to explain why there was nothing wrong in the General Court's assessment. But more importantly, I keep the clarification of the clarification.
There's also a temptation to ask more about the as efficient competitor test, but we will discuss it when discussing the draft guidelines itself. Let us move to the next landmark case, Google Shopping.
Yes, Google Shopping is, a case of the Grand Chamber of the Court of Justice. It represents certainly an important principle when it comes to the application of the non-application of the Bronner test to these types of practices. And indeed, you can say that as a result of that line of case law, we have now a new category of cases. You could call them self-preferencing types of cases. You could call them access restrictions types of cases. These are cases which, according to the Court of Justice, there is conduct which has certain elements. I mean, we can call them self-preferencing elements, but at the end of the day, the court is very hesitant to apply Bronner to this type of conduct because for the court, in reality, the dominant company was already dealing. It's not that we have a refusal to deal with a particular customer. There's already pattern of dealing. It's just that the terms and conditions, if you like, of that dealing that create the issue here. And the issue here was the conduct behind self-preferencing, which was the demotions and all that. I mean, the court explains that very well. Although I'm on the losing side, as you may know, in that case, I like the judgment. I like the judgment because it has a lot of other interesting stuff to say. For example, it's clear that we need a causality. The causal link is very important. The Court of Justice, for the first time, I have to say, specifically mentions causality as one of the conditions. When it comes to explaining all circumstances, which are these all circumstances, very clear, what the court is saying, but these circumstances may have to do with objective factors, but also with elements of the behavior of the dominant company. We have some very interesting references to the insufficient competitor test. For example, the court says in appropriate cases, the test is the way to go. And by the way, it doesn't say the commission may, it is the way to go. It's actually pretty prescriptive, I think, the language that the court uses there. In this particular case, the court says that this was not one of those appropriate cases. So although, personally, I would have liked this case to be subject to the Bronner test from the very beginning. In the end, the court doesn't go there. Fair enough. But I think if you read the judgment, it makes a good reading. It's very well written, I think. And, habemus papam, we have new case law now on these types of self-preferencing cases. I also like to mention specifically paragraph 186 of the judgment, which kills the idea of a general principle of equality in Article 102. That's not the case. The court explains that it's not that dominant companies must always treat their products, their services in exactly the same way like those of their competitors. No, it's just in this particular case, because of the very specific circumstances, the ones I described before, the conduct at issue is against competition on the merits and indeed capable of producing anti-competitive effects. That's important, this paragraph 186, because apart from killing the too expansive statement of the General Court, it also kills one of the examples that the Commission had given as conduct going against competition on the merits in the draft guidelines. So one of these examples we know for sure in the final guidelines will not be there, precisely because of Google Shopping.
We also have last year a remarkable development with sport cases trilogy, and also this year we have the Lasana Diara case, among others. Important trajectory of development of competition law as well.
Yes, I mean, we had one case this year, which is Lasana Diarra. By the way, the name Lasana Diarra is not there because of this policy now in the Court of Justice of anonymization. I don't like this policy because we would have never known about Mr. Flaminio Costa or Madame Defresne or you know what. But anyway, it is what it is. But we knew that it was this footballer at stake here. I mean, it was his contract at stake. I mean, I'm not going to stay with this particular judgment. All I want to say is that all these cases, obviously, in reality, they owe a lot to the main case, and the main case is European Super League. European Super League is the standard, essentially, for all of these cases. And there will be many more. There are some cases currently pending with the particular question being the arbitration, sport arbitration in these bodies, etc. So we will have more in 2025 on sport cases. But I go back to European Super League because as time passes, and we had mentioned European Super League last year, you remember, last December, but as time passes, we kind of realize more and more the fundamental nature of that judgment for competition. Although it's a sports case, although sports cases of this kind, and in particular the conduct in question and the dramatis personae, so to say, were very special circumstances there at stake. Still, it seems to me that we can see it already, that the court produced a restatement of the law, both on Article 101 and on Article 102. On Article 101, this restatement essentially says that vouchers, ancillary restraints, etc., do not apply when you have by-object cases. So the court there takes away something with one hand, but at the same time, the converse of that, and this is what the court gives back with the other hand, essentially the court says that from now and onwards, I will be quite restrictive in how I read by-object cases. So the other side of the coin, if you want, of the non-availability of the vouchers and the ancillary restraints defenses for Article 101.1 is the restrictive reading of by-object vis-a-vis the previous case law. So essentially the court says, and you know, I mean, I was quite worried when I saw that vouchers and ancillary restraints would no longer be available. And I said, you know, is it a good thing? Because sometimes the court may need to regret that, because you may have specific facts. It's clear it's a by-object case, and then again, you cannot use. What are you going to use then? Article 101.3, good luck to that. It's a very difficult route, as we all know. Whereas vouchers produced this way out, so to say. But the way I understand it, and I can tell you that I have a very informed view on that, speaking to people, etc. My understanding is that this new line of case law, this restatement on Article 101, means that the court will be dealing with those boundary cases by playing on by object or by effect. So I think when the court in the old days would be ready to apply vouchers, here they will say, maybe this is not by object. This can only be by effect. So I think that's what the court has taken with one hand and has given back with the other hand there. On Article 102 also, it's a very important development. The assertion competitor principle is mentioned, but at the same time, the court includes a phrase, which is important, which essentially says that, yes, a sufficient competitor principle, but at the same time, we need to have our eyes and ears open when you have an extremely strong dominant company, essentially, in this case, a monopolist, which controls also access to the market. I mean, if somebody entirely controls access to the market, then what kind of efficiency are we talking about, and as efficient competitor and all that? I mean, we know for sure that this is a unique position essentially, and there's no need to go to the as efficient competitor principle. So it's a major statement, and I think we will see it cited many times in the future in the case law of the Court of Justice. I was wondering why you haven't asked me so far about Illumina Grail, because some people consider this as the major development.
Because it is exactly on the next question in my list. Let us move to Article 22 of or the interpretation of Article 22 of merger regulation and the recent judgment, 2024 judgment on this matter.
Yes, I mean, first of all, I think this was the last major competition law case where Niels Wahl was the juge rapporteur. It was rendered a few days before his departure from the Court of Justice. I think he will be missed, not by all, maybe, but by certainly some of us, we will miss him, if only because I think he definitely had a huge, he left a huge mark with the court. I mean, the economic way of thinking, even, his cartel cases, you read the cartel cases that he has produced, which of course he never went against the commission in those cases, but, or some private enforcement cases where he explains in a very nice way the economic nature of harm, for example. We will never see that again, I fear. I mean, he was a great judge. But to go back to that particular judgment, it's a huge coup. I mean, definitely for the commission, it was huge. I think the court adopted a principled way of dealing with the case, and essentially the court is saying, no, commission, I'm sorry, you cannot legislate. You cannot legislate. It's only up to the legislator to deal with that. And in this particular case, the member states, the commission cannot buy, let's say, from a non-owner, to be honest. In other words, if there is no national competence, if there's no national jurisdiction in the first place, the commission cannot get anything. You need to have national jurisdictions. If you have national jurisdiction, then that can be referred. If you don't have national jurisdiction, you cannot have a reference, essentially. You cannot have a referral of this type. And I think that's very important. Now, of course, the devil will lie in the detail, because, as you know, currently the commission is saying that, and also the national authorities, well, we can still use Article 22 if the member states authorities have call-in powers. Call-in powers essentially are powers where the NCAs would say, well, you don't fall into any of our thresholds, but the law gives me the power to kind of call you in, so to say, to kind of so that you can come and explain. And I want to kind of review your transaction under these very exceptional powers. There is a couple of paragraphs in Illumina Grail which could be read as not allowing, not even that type of referrals, for example, because there the court mentions the importance of thresholds-based kind of referrals, that for jurisdiction, essentially, you need to have a threshold being satisfied nationally. Then there's a big question, does it need to be turnover-based thresholds, or can you have market share thresholds, like, for example, you have in Germany and other countries? So I think that's not the end of the story, I think, for the next days, but certainly this case is major. It has created a lot of difficulty to the European Commission. The way I explain this case beyond the law is the Commission made a huge error here. The Commission should not have, in reality, sent this letter or actually approached the French authority to ask for a referral, and in any event, the Commission should not have accepted the referral before it revisited its guidance. Because what happened here is that the whole process nationally started even before the Commission revisited its guidance. So I think, in my view, in terms of optics, this was quite daring, I have to say. I'm not sure the end result would have been the same if the Commission had first changed its guidance, explained that to the general public, and then put in effect the new guidance, so to say. I'm not sure. And again, this is not a legal explanation, because this particular issue did not play a major role in the court's reasoning, but I'm talking about what lies behind, in the context.
Speaking of what is lying behind, I heard on a few occasions Olivier Harson mentioning that his reading of the judgment is that basically the court somehow acknowledges this teleological interpretation, but saying that, well, it was so many years ago. Of course, I'm paraphrasing, and he is making it kind of a little bit simplifying juristic side of this. But does your reading of this judgment would allow for such a conclusion that it was somehow saying, okay, if this is the message, if that was the message, can you please reinstate it in 2020 plus?
Well, I think what the court is telling the Commission, and it's clear, the specific paragraph, it's saying you have the means under the regulation. There's Article 1, paragraph 5 and 6 of the regulation, which provides for a simplified procedure which doesn't need doesn't need unanimity to change the thresholds and the criteria, because those paragraphs mention also the criteria, not only the thresholds. So the court is telling the Commission, sorry, this is the way to do it. I don't think the court, I wouldn't go into teleological interpretation or anything like that. I mean, I would just say that the court certainly went through all the arguments used by the General Court to explain its position. And in the end, one after the other, the court disagreed with all these arguments, essentially. It's a bit cryptic, though, because, the court doesn't really explain very much how to depart from the plain letter of the provision, which was quite generally phrased. So I think in the end, of course, the court was influenced a lot by the legislative history here behind. I mean, and I'm sure the parties did a great job in terms of putting all this legislative history before the court, and so that the Advocate General first, in his opinion, and then the court go there.
There are a few cases which have not necessarily generated headlines in general media, but they are important juristically. If I can ask you, please, very briefly summarize the key outcomes, Portuguese bank case and Greek beer case.
Yeah, I mean, the Portuguese banks case is an interesting case because of the object or effect type of analysis there. It tells us that it doesn't matter how many exchanges of information we had. One exchange of information is enough, for example, under the circumstances, to bring a particular practice under the by object box, so to say. The Advocate General's opinion here was one of the best, I think. Advocate General Randos had produced a great opinion again on in this particular case, and the court followed Randos. So for me, this exemplifies the by-object kind of new world that we are living in after European Super League. Sorry, you mentioned another.
Greek beer.
The Greek beer case, that there's a Greek element here, which is very interesting. Here we had an infringement decision some 10 years ago by the Greek Competition Authority, the Hellenic Competition Commission, against the local Heineken subsidiary in Greece. And the lawyers of the complainant were quite ingenious, so they sued for damages in the Netherlands, not in Greece, right? So they sued for damages in the Netherlands, and they went after Heineken, which is the parent undertaking of the Greek company. So the question here was a jurisdictional one, whether there was jurisdiction in the first place, and the court applied the single economic unit doctrine in reality also when it comes to jurisdiction, and gave a big boost, let's say, to private actions in this case. Of course, it's an interesting case because I think this will be the first ever case where the particular paragraph in the damages directive about the prima facie type of evidence weight that has to be given to other NCA's decisions in third countries within the EU, obviously, of course, will have on private litigation in member state A. So you will have a member state B infringement decision, and the action for damages will be brought in member state A. And that is essentially, let's see about this particular point of the prima facie evidence, essentially how, what the final judgments will say there, because I believe there's a number of proceedings in this case which are currently going on.
There is also a commission decision on Apple Spotify, where, among other things, it requalified this prima facie exclusionary abuse to the into the exploitative one, and it bears a lot of implications, conceptual and maybe substantial.
Yes, this is a case, for me, this is the most important decision of the Commission this year. There is, of course, the headline grabbing element of the fine. As you may remember there, I think the fine was, normally it would have been, I think, 40 million. And then the Commission added for deterrence lump sum of 1.8 billion. By the way, under the Trump administration, forget about these fines anymore. I mean, I don't think the Commission will make a mistake when it comes to these types of headline grabbing fines. Commission can still be quite active when it comes to remedies, etc. But these types of fines, I think, will take long until we see them again. Anyway, I stop this excursus, go back to the case. This is an interesting case because in that case, we had an exclusionary theory of harm. It was being run as an exclusionary case. There was a statement of objections. I think the statement of objections, the first statement of objections was something like raising rivals' costs type of theory of harm. And then volte-face, everything changes. There's a new statement of objections. It was not a supplementary statement of objections. There was a new statement of objections. And the new statement of objections goes for an exploitation theory of harm. The interesting thing here, and I think that's what saves this decision in my kind of critique, let's say, and that I don't criticize it because I'm fine with what the Commission has done there, is that it's not that they said, okay, I will not have an exclusionary theory of harm, I will run it as an exploitation and the victims are the app developers. No, the victims in this case are the users. So in that I think is something that is defendable. And I mean, I don't know what the court will, it will be very interesting before the court, before the EU courts. But I think I'm not bothered from a principle point of view if the Commission changes an exclusionary case to an exploitation with victims, however, downstream, essentially, the end users. At the end of the day, as I say when I sometimes teach, is all exclusionary cases are exploitative cases, all of them, because we intervene because of consumer harm. That's what it is. So if the Commission, and I haven't read the decision, if the Commission found a good way to describe this conduct from the point of view of the ultimate victims, supposed alleged, because nothing is, there's no final judgment yet, then that's good. And I think that's something that we may see more and more in the future. I would have I would have been jumping if the commission had said, okay, then it's unfair terms vis-a-vis the app developers. No, sorry, then it's not as good as that. I mean, I wouldn't like to see something like that, because that's an easy way out, and that's a sneaky way out. Instead, here the theory of harm was a real exploitation case. So let's see what the courts will say.
And this could probably, projecting in the future with the follow-on actions, this could somehow trigger the passing on defense argument as well.
Yeah, it's possible. I mean, I haven't read the decision. We'll have to see what the commission has put in. That may be helpful, possibly for litigants. But yes, of course, always it's extremely difficult to prove in one or two cases. It's extremely difficult to prove harm for consumers. Especially when this is not about excessive pricing, this is about loss of choice. How do you measure loss of choice? I mean, and what's the causality here? These are very difficult cases. It's not easy.
I'm very eager to revert to Marcus Komninos as thinker. And this is for the third part of our conversation, where we'll be discussing the tailoring, the issues related to tailoring of competition in digital markets. But there is the second one as well, related to the elephant in the room, just the draft guidelines on exclusionary abuses. A lot is going on in this field. We have 112, I think, submissions have just been published. So as a Christmas gift for some. But even before this, we have a lot of materials to learn and to read and to entertain ourselves and to learn. And you've been one of the most eloquent and outspoken commentator
I
of
accept
this.
the
You could
accept the
trigger.
outspoken for sure. Yeah, I was quite outspoken. That's clear.
Well, this only demonstrates the power of the argument. So let us before reverting to the substance, I wanted just to your clarification, maybe for those of us who are not so deeply into this topic. The discussion on the guidance and guidelines. Why it's supposed to be so important? Particularly, we hear some comments from judiciary authority that in both cases we somehow almost the commission is almost acting ultra vires in a sense. It's not for them to say this. How do you draw the boundaries in terms of competences?
Look, I think there are two levels here of discussion. The first level is, I think, in terms of a policy, if we see this as a kind of policy document. And there, unavoidably, one has to compare it with the guidance paper. The guidance paper had a fresh kind of a fresh mind type of setting, essentially. It was written in a way that you had a lot of new ideas. For us lawyers, you were reading it and you would see new things, essentially. You would see things that you wouldn't recognize from the case law or the decision or practice of the commission to a degree beforehand, right? I mean, you had all this economic parlance, but at the same time, there was a new world opening up, a world based on theories of harm, or a world based on consumer harm, the fundamental distinction between the anti-competitive foreclosure, pro-competitive foreclosure. It was a document drafted in a totally different way, and it speaks at a higher level, let's say, but at the same time, it offered a degree of comfort, of course, not necessarily tantamount to full legal certainty, because a full effects-based analysis, as you know, there's a lot of legal uncertainty in that. If you want to have a great legal certainty, then you should have either per se rules of permission or per se rules of prohibition. Then you have the absolute legal certainty. But that's the easy way to do things. The difficult thing that the guidance paper did was really to educate us all, and in the end also the European courts, in thinking in these economic terms. So in that respect, I think the guidelines fail to excite, because the guidelines are just a legal document written by lawyers. I have the feeling sometimes as if I'm reading a pleading of the European Commission in court. So I don't think it offers a lot of legal certainty. Yes, I mean, in terms of being more restrictive when it comes to exclusivity rebates, for example, exclusive dealing, etc. I can see that some companies might say, let's not go there in the first place. So that's one level of analysis, to compare the guidance paper as a kind of text, as a kind of policy document with the guidelines. The guidelines are not a policy document. The guidelines are only a systematization of the case law, as they say. The other level is the relationship with the case law. And here, I respectfully submit that the guidelines have many problems. The guidelines are based on a very selective reading of the case law. There are areas of the case law which are respected. For example, the access restriction part or self-preferencing. Yes, the guidelines reflect the latest case law. But the other areas, for example, exclusive dealing, exclusivity rebates, tying, I would say the margin squeeze type of analysis, where the guidelines depart from case law. Depart from case law. And let me be clear about that. The case law does not support this stance. In particular, if we want to speak more generally, the idea of presumptions is not supported by the case law. I'm happy to go into each and every of the footnotes that the Commission has used to support the idea that there is a presumption. No, I'm sorry. The only presumption that the case law has recognized is when you price below average variable cost. And that I had also admitted in my Jacques article, and I'm glad to see that in Qualcomm, the court agreed that this is the only presumption, when you are below average variable cost. But apart from that exceptional case, the court does not recognize presumptions in the way the Commission views presumptions in this document. If you read footnote 131, they say by presumptions, we mean allocation of evidentiary burden. No, I'm sorry. The case law does not allocate the way the Commission suggests allocation, the evidentiary burden.
Can you please just here on this point explain what is at stake here, with whether there are presumptions or not?
There is a theoretical and a practical element here. The theoretical element is this is a mistake. This is a legal error. I respectfully disagree. There are no presumptions under Article 102, as I said. Why? Because, essentially you need to prove that the fundamental legal tests are met or not at the end of the day. And I don't see anything there suggesting that for specific practices, you have an easier, let's say, evidentiary burden if you are the Commission than with regard to other specific practices. There's an additional problem always, and the problem is that if you go through the categories of cases, category A, B, C, D goes to presumption. Category E, F, G, etc. goes to full effects-based analysis. How are we going to categorize what fits into this group or that group? The Commission here, and this is where the formalism lies, the Commission here in reality is going to the external characteristics of conduct. In fact, there's a specific paragraph. So if you look at the conduct, the external characteristics of conduct, the form, and say, this belongs to category A as opposed to category B. Yet between category A and category B, there may be thousands of differences essentially when it comes to the legal tests, etc. The Commission does not go to the theory of harm that it should have gone to explain why one practice is there, another practice is elsewhere. That's already a first big issue that we have with all these groupings and categories, etc. The other problem I see is, as I say, that there is no such thing as a presumptively exclusionary practice. That is one thing. Of course, in reality, there's a difference in terms of, let's say, the standard that the Commission has to satisfy with regard to specific practices. Like, I mean, if you destroy your own property because you want to harm your competitor, I mean, we're not going to have to need to prove a lot there, right? I mean, there is a standard which is much easier for the Commission to satisfy. There's no doubt about that. So I would be happy with a sliding scale of evidence that the Commission has to satisfy with regard to different types of practices. Of course we have that. There's no problem about that, but not to have allocation of the evidentiary burden by the Commission. I'm sorry, that's not what the case law is about. That's theory. Let's go to practice now. Will this make a big deal, a big difference? No, in terms of Commission enforcement. Why? Because as the Commission itself suggests, and it couldn't have said anything different because that's the case law, the dominant company can always come forward and produce economic evidence, the AC test, other types of evidence, and so on. So one asks oneself at the end of the day, what's the big deal behind all these presumptions? And at the end of the day, if these presumptions are soft presumptions, as the Commission recently has started to refer to them, why do you need them at the end of the day? Why do you need to speak about presumptions at the end of the day? If the dominant company can always come forward, etc. The big difference, however, practically speaking, always is who is the decision maker. I believe that at EU level, the European Commission will never be stupid to go to the courts on appeal with a presumption type of approach. That's clear. I mean, okay, there will be some propaganda type of paragraphs at the beginning, say, for these types of practices, these are bad, blah, 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 there's a presumption, etc. But then, the dominant company came forward with the evidence, and then here is the following 2 or 3 or 4 or 100 sections, essentially, rebutting the evidence of the dominant company. So, in real life, for Commission decisions, it will not make any big difference because then what is at stake is judicial review. And there it's a case law that governs this. Where I think it will make a difference, and that's why I fight a lot against these guidelines, is the member states. The member states is a different situation. I'm afraid that these guidelines may be taken as the Bible by some NCAs. In some member states, you don't have a lot of judicial review, let's say, let me put it mildly, let's say judicial review is weak, right? As opposed to the General Court and the Court of Justice. So there, I fear that we may end up with perverse effects, perverse results. So you may have, for example, the super dominant companies that are under the Commission jurisdictions being better off because of the judicial review than the mini dominant companies, if I'm allowed to say, in the member states, where there's a dominant position, a particular market, and so on. But then this case is not going to go to Luxembourg unless, of course, there's a preliminary reference. But okay, good luck to that. So this is why I'm very much against the guidelines, also from a practical point of view. Theoretically, I'm against them because I don't like all the elements I described, but also practically, they do raise issues.
The draft guidelines.
Sorry, the draft guidelines, yeah.
Let us move to the other four things, for the remaining 4 things which you have identified in the published draft guidelines.
No, I mean, generally, as I said, formalism, I explained what I mean by formalism, these categorizations, the fact that you don't really concentrate on consumer harm and on theories of harm. That's one thing. The other thing is the presumptions, which I don't like. The third thing is, of course, the fact that you have a departure from the basic principles of anti-competitive foreclosure. I mean, that's something that I don't like. The Commission should have explained that you may have pro-competitive foreclosure and anti-competitive foreclosure. What is anti-competitive foreclosure? Foreclosure that leads to consumer harm. And by what do we mean by consumer harm? No, we don't mean the Chicago idea of does it raise prices. And even the courts, I mean, in fact, the courts first than anybody, have explained on many occasions that in Europe, we have a different way of seeing things. Consumer harm means losses, not only in terms of price, but also in terms of quality, innovation, choice. But this is why a foreclosure can be anti-competitive, because of the consumer harm that is produced as a result of that. So I think that is very unfortunate that we don't have that starting point for the guidelines.
Can I pick one point in this discussion, which I hear quite often, that the case law is very cryptic. Some people say impenetrable, others say convoluted, and we can hear it from different camps, so to say. So it's a kind of it's a description of the state of affairs in the area, probably because the stakes are so high, and because the standard of what is being discussed is relatively narrow. If this is the case, can we say that the current draft of the guidelines is not informed or is applying or interpreting the case law selectively? And if it is the case, that isn't it the case that everybody is trying to interpret the case law selectively, or there is kind of proto-objective reality which we all, those who understand all the nitty-gritty of things, would consensually agree?
Look, as I've said many times, and maybe I have repeated it last year when we were talking, in Luxembourg, in the courts room, there is no kind of central computer somewhere in the dungeons that controls everything. So cases are decided on the basis of their facts, sometimes in a haphazard way, I'm sorry to say, but that's how cases are decided. At the end of the day, it may shock you when I say that, Oles, but there is no absolute truth when it comes to Article 102. Article 102 is not about morality. Article 102, the case law at least on Article 102, is about the persuasiveness of specific decisions of the European Commission. This is how the case law works. Has the Commission done a good job there? Does it have a good story to tell? Has it cut any corners, for example, and so on? It's about the legality and, of course, the persuasiveness of the specific decision. This is not about the truth. There's no truth at the end of the day in Article 102. I mean, look, in the Microsoft case, the famous Microsoft case in 2007, when it was adopted, there is anecdotal evidence. There are people who are saying that in the end, the court decided on a 7-6 vote. So the Microsoft case, the big standard, the case of cases, the mother of all cases, could have been different if one judge had a different mind. I mean, come on. There is no such thing as absolute truth. It's a question, however, that has to do with persuasiveness. And that's important. We tend to forget that. What is at stake is how good was the Commission's work in preparing a decision, defending sometimes a decision, was it good or not? And whether the other parties have made good arguments in that sense. Now, the case law is not great, obviously. You read cases such as, first of all, you have cases which say one thing, another case says another thing. For example, a good example is Unilever Italia, which I like as a case, generally speaking. But Unilever Italia uses the word or between conduct against competition on the merits and capability to foreclose, referring to Servizio Elettrico Nazionale, which uses and, right? And then, of course, in European Super League, the Court of Justice corrects the error and says in reality it's and, right? And now even in Google Shopping, it's and, obviously, and so on. So, stuff like that happens. Or you read the Servizio Elettrico Nazionale. This case has everything and nothing at the same time within it. Because everything that pleases all different types of kind of groups, let's say, is there. But does it make it a kind of clear case? No, I would submit not, right? So the case law can be like that. Now, the fact that the case law is like that, the fact that there may be errors in the case law, mean that a fortiori, I submit, the Commission should have been more, let's say, to the point, more intellectually honest, to the point, and say the Commission should have said, for example, this is the case law, but with regard to these specific practices, I have a problem with that case law because of A, B, C, D, E. And the way to go is this, because of these reasons. Now, if the Commission were to do that, do you have a doubt that the Commission would lose in court? If you would have, for example, a well-reasoned decision that explains why this way is not the way to do things in this particular case, do you think that the Commission would lose in Luxembourg? I don't think so, personally. But unfortunately, this is not how the Commission has drafted these guidelines, I have to say. It is selective at times. Sometimes it reflects accurately the case law, but some other times it doesn't. So there's a lot of selectivity there. And of course, there's nothing that explains why the Commission is going against the particular case law. The Commission pretends that this is the case law, but that's not the case. If the Commission had explained, then we would see, obviously, in cases when they go before the court.
Do you think that mutatis mutandis, we will have a similar narrowing down of the enforcement discretion with the DMA, with the first judgments knocking the such generous discretion which we currently appear to have, which the Commission appears to possess within the legislation, into the least anticipated predicted procedural maybe, or even substantive parts of the first decisions which will go on appeal? And don't we already see it with ByteDance TikTok?
The ByteDance order, I would leave it aside because it's a very special, the judgment, I would leave it aside because it's very special. It's about designation. Designation is a special procedure. I wouldn't draw, I mean, it's an important judgment for designation purposes, but not for substance. I would leave it aside. Why? Because, and I think I have written something about that in the past. If you read all these provisions in the DMA, the substantive provisions, in reality, these provisions are made of many imprecise legal concepts. Imprecise legal concepts, a term that the court uses. And when it comes to these imprecise legal concepts, especially now that we're dealing with regulation, there is a duty, if you want, on the regulator to give guidance on these issues. So therefore, we'll have to see when we go to substance whether the Commission has done a good job in terms of discussing these particular provisions and has given the right degree of guidance to gatekeepers. That's very important. By the way, I have changed my views always on the DMA. Before, I thought that I was seeing the DMA as, you have on the one hand the competition rules, Article 102, it's a general clause. And then, on the other hand, you have the DMA, 21 per se prescriptive rules, obligations, etc., etc. In reality, self-executing. In reality, nothing is self-executing. There's a lot of discretion here. There's a lot of discretion. So, there's a lot of discretion in the hands of the Commission, there's the regulatory dialogue, and so on. They have direct effect, in my view, but they're not self-executing in the sense that everything is clear, it's 1 + 1 makes 2. No, it's not like that. So, or in terms of the court's judgments in the future, we will see again whether the Commission has done a good job or not in this when it comes to these decisions.
But it can shoot itself in the foot occasionally with bad decisions on the DMA. So the role of the first decisions in tailoring the scope of this discretion is pivotal.
Yes, I mean, I'm with you there. I think that although I like always to say that compliance with the DMA is not a static process, it's a dynamic process, but I think that what is happening within this first year in the dialogue between the gatekeepers and the Commission is very, very important, because this will design also how the gatekeepers will act in the future. So there is a difference of degree, I think, as to what is happening in these 12 months since March 7, I think.
And the second part of this question is the role, how do you understand, maybe not necessarily being involved on daily basis, but as an observer, trying to put everything into kind of more or less coherent understanding of how the planets are rotating in this universe. What is the role of courts and judges in such supposedly groundbreaking or decisive junction of the development of this important area of EU law, bearing in mind all these kind of geo elements of all the drug and letter report, etc. So they, with one judgment, can narrow down the scope of discretion and the potential of this legislation, or somehow permitted leaving it this margin of discretion greater, and thus the activism of the enforcer greater as well. How do they understand their own role, and how they should understand their own role?
Yes, I was recently at a nice hearing, I think at the OECD, where they had invited former Judge Niels Wall. And he was explaining when he was, I think the topic was standard of proof and this kind of stuff. So Wall explained very nicely that when we sit down at the deliberé to discuss and decide a case, we don't start from the premise, what should be the standard of proof here? Should it be beyond, reasonable doubt? Should we? No, this is for us. This is for the commentators. This is, this is at the end of the day for, the observers to kind of make the case what they think the case is about. No, the judges are always, again, go back to what I explained before. This is not about morality. This is not about the absolute truth. This we leave to criminal law, or to religion better. We are dealing with the economic phenomena, which is about the phenomenon of competition, right? And we're dealing with Article 102, or we're dealing with the DMA, which again, as I said, has many imprecise legal concepts. What counts is whether the Commission makes a good story, a consistent story out of the facts, right? We have the law. This is what the law says. Maybe clear, maybe not clear. The Commission will have to make a good story out, first of all, of how to interpret the case, the law, sorry, and then how do we correspond, how do juxtapose the facts to the way you interpreted the law. And if you do a good job, if it's persuasive, at the end of the day, it's how the case smells, right? I mean, if it smells badly, you may have great legal arguments and so on, but if it really smells badly, you will not win this type of case. I mean, that's not gonna work. So I think that's how judges work. Judges, of course, are ultimate refugium, so to say. This is the legality of Commission acts. The Commission definitely takes the courts into account in a lot. I mean, I can tell you even in this process, in the regulatory dialogue, I'm sure the Commission is always saying, "Ooh, would we be able to defend that in court? I mean, can we defend this in court? Or what happens? I may agree with you, gatekeeper, but what happens if a third party, for example, goes to court and blah, 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 blah?" All these are in their minds. All these questions are in their minds. So it is the ultimate, let's say, safety valve for legality. But at the same time, the court is a world on its own, let's say, and they're not technicians. They're just there to ensure that the Commission has made a good decision. The technicians, I would say, are within the Commission at the end of the day when it comes to the DMA. But that doesn't mean that the Commission has has more leeway, because there's no margin, if you want, of discretion because these are technical matters. No, there's a certain margin of discretion of being the Commission an administrative authority, obviously. But at the end of the day, you really need to do a good job in putting down the facts in a nice way and your theories in a nice way, in a consistent way that makes sense.
Let us move from judges to the enforcers in their kind of way of thinking. You mentioned at the very beginning, once the DMA has only been published a draft of the regulation, that it is a regulatory regime presupposing daily engagement of different of the enforcer and the regulatees within this regulatory dialogue. Not everything must be somehow explicitly published, and there must be some intimate communication in order to discuss nitty-gritty on continuous basis. That's how the regime would deliver in the long run. And
with appropriate safeguards. And
with
there
appropriate,
are
as
workshops.
mentioned.
I'm sure third parties are also meeting with the commission and so on. It's not that
Yeah,
this is
yeah. Yeah, but my question, for me, this is a given. That's the only way how to succeed. I fully acknowledge this as a descriptive element of the new reality. But what the question which arises is that it also changes, or it's supposed to change the vision of the enforcer. They must think strategically. Once having this room for maneuver, they would obviously discuss in the technicalities, but having something in mind. I know some people would say that in the long run we all die, etc. That's nice metaphor to caricaturize this, but there must be some strategic vision about this within underpinning this regulatory dialogue. Do they have to have it? Do they have to share it with others, or they have to keep it somehow this kind of big idea within for themselves? How would you rationalize this?
It's a very difficult question. It's a very difficult question because at the end of the day, I think what lies behind your question, and I have thought quite a lot about that, is what are these rules at the end of the day, and what do we want to attain with these rules, right? And is it enough, for example, for the gatekeepers to comply with the letter of the rules and the spirit of the rules also? Or should we be looking at results? For example, is it, as we say in French, is it an obligation de moyens or is it an obligation de résultat? In other words, is it enough to comply with the rules and then that's it? Or do you need to have outcomes in the market, right? I mean, the answer to that is that I think it's an obligation de moyens. You need to comply with the rules, with the letter and the spirit of the rules. This is not about outcomes. Outcomes are for the legislator. If the legislator had some outcomes in mind and these outcomes have not materialized, that's a different story. So I don't think the Commission must have, or indeed should have, a kind of strategy in terms of outcomes. I think the Commission should have a strategy in terms of law, how to interpret the law, in terms of process, how do we arrive at the decisions, for example, and also in terms of short-term outcomes, in the sense that, let's say a particular article 6.5, which is on self-preferencing in a particular industry, a particular gatekeeper, right? What does the gatekeeper in this particular case have to do in order to comply with, the law at the end of the day? If it happens that 1,000 new flowers kind of bloom, that's good. But if not, I mean, at least there has been compliance with the law, and then, of course, the legislator will have to draw the consequences. So I'm not so sure that the Commission should have necessarily long-term and high-level objectives, etc. That's not, I think, for the Commission as an enforcer or a regulator here.
Okay, and thus my next question makes very little sense because it somehow anticipates this. But let's assume that partially the Commission knows that it's not an axiomatic box ticker. It somehow it is mindful of its scarce resources and it selects priorities. Within this regulatory dialogue, do you think it can be possible to reach somehow a point where both parties would somehow, where the gatekeeper might say, okay, tell us what you want really, And once we deliver really what you want, you leave us alone for X month or so and refocus your limited resources on doing something more important. Can it be somehow win-win in this? Isn't this a model which is anticipated in this participative approach?
Well, you may know that in Article 102, we had in the Microsoft case where I was personally involved. I mean, this was the main issue when it came to compliance, because back in those days, Microsoft would write to the European Commission and say, please tell us what to do, how to comply with the order. And then the European Commission would say, oh, it's not possible for me to tell you. I mean, you have a general injunction, do what you must in order to comply. So I think that will change a bit in the DMA area, because I think the Commission is now a regulator. The Commission has to really have the dirty fingernails and try to give guidance. These are imprecise legal concepts. I would advise the Commission not to play entirely the game like it used to play in antitrust, because this is different. So I would give guidance. Of course, guidance can come also with preliminary findings, with the stand of objections. That's also, but guidance, so you must have. I mean, that's clear. But of course, I mean, how prescriptive that guidance, or whether you need to do whatever. I mean, you need to choose a particular number when it comes to front. I don't think that the Commission would do that, honestly. The Commission will give more, I think, in the DMA than it used to be giving before, in terms of hints or guidance, or even being a bit more prescriptive. That I expect to happen.
Last question, dear Assimakis. It's a Christmas, pre-Christmas, post-Christmas, depending on how you celebrate it, period. A Christmas gift from you. How do you process such abundance of cases? How do you select those readings which you have, again, abundance of? Now we have 112 submissions, comments on the draft guidelines. Would you give priorities to, in your scarce time, to reading a case, yet another case, or rather submissions where you somehow anticipate in advance, depending on who is commenting? What is the algorithm of dealing with such a cacophony? How to create a symphony out of cacophony?
There is, as you put it, there is no algorithm, unfortunately. There is a lot that you have to do yourself. I have reached a certain stage in my career where there is a thing called instinct, always. So I'm driven quite a lot by my instinct, I have to say, when it comes to cases in particular. I can read the judgment of the court in a certain way based on my instinct. I know how to go through quickly the paragraphs. I know where to look, for example, for the juicy stuff, because I've been doing that for ages. So, it comes with experience. As for how do I deal or select cases, I do not select cases. Cases come to us. We are lawyers. When it comes to my practitioner, let's say, side, I do not select anything. I mean, it will come to us, and we'll have to do our best to defend our client and to present to the courts an alternative way of seeing things. Obviously, as a part-time academic, I have some more specific interests there, and I do try to select, although time is not always available. But that's a different story. I don't want to say more as the selection when it comes to academic papers. As you know, as Henry Kissinger used to say, the debates, academic debates, tend to be the worst, because the stakes are so low. Although I don't believe necessarily what Kissinger said there, but it is indeed the case that in the academic world, these types of debates can be quite deadly sometimes. So I prefer not to take part in that discussion. But it's a complex world. We live a world of complexity. When I started as a lawyer 20 years ago, more than 20 years ago, but I don't want to betray my age although it's quite well known. But anyway, back in those days, we had essentially general EU law litigation from time to time. You had interesting cases, sometimes some appeals from bodies of the Commission preliminary references, and then you had 101 and 102. And that was essentially cartels, some abuses, and of course you had merger control. Nowadays, it's so complex. You have antitrust, which has become extremely complex. It's not as it used to be 25 years ago, clearly. And then you have all these new tools. You have FSR, you have the DMA, you have the DSA. You will soon have the AI Act, where the Commission has some exclusive competence. I mean, it's so complex. It's so, and then of course you have the national competition authorities, which, I mean, when I started doing competition law, there was only two. In reality, there was only two systems working: the German system and a little bit of I don't know, French, Italy, and that was it, and the UK, obviously. But that was it. Now you have all these different players, and they are extremely ambitious. They want to be part of what we would call the European common law of competition. All of these players are important players. So it's an era of complexity, what we are living in.
And with this in mind, traditionally, recommendation to students.
Oh, my recommendation is always the same, which is be intellectually curious. Don't take everything for granted. I mean, you can question things that you hear. Be hardworking. That's clear. Hardworking, I don't mean to work until 1 a.m. That's not what I mean. But hardworking, I mean in terms of be intellectually curious and invest in what you like. At the end of the day, try to do what you like. Not turn yourself into a robot lawyer, as I have said in a recent interview, but really be a thinker lawyer if you can. I think if you do that, then you will have a good life as a competition lawyer, certainly.
Assimakis Komninos, thank you very much for sharing your deep ideas with all of us.
Thank you again. I wish Merry Christmas to those celebrating, Happy New Year to everybody, and I hope we talk again next year.
For sure.